1561. Page 1561. One of the respondents' counsel, the second respondent's counsel, and 1561, 1561, volume 4. I actually, my case rotates around volume 4. Fifteen 1561. 1561. Line 9, sentence at line 9 starting with employer. Employer came to court to seek injunctive orders. Court went further to look at the cause of the strike. It is actually the court that went further than the case before it. And my lords will recall that when confronted, counsel for the second respondent, the name is indicated at 1561, Mrs. Guselwa, 1561, that is counsel for the second respondent, Coupet. And this is under the subheading by the judge of jurisdiction. My lords will recall that when confronted with the application to set aside what is the foundation, or what the judge considers to be the foundation of his jurisdiction, that is the consent, the judge at page, Lisa, what page was this? 14, yes, I have it. Paragraph 22, which would be page 1413, page 1413, still on volume 4, 1413, line 1, the sentence, the applicant was in law and fact stopped from lineaging on the consent it had fully participated in crafting and having enjoyed the fruits of the consent order. So the judge, whichever way he goes, he turns round to the consent. It is because of this consent I have the power to determine basic salary. My lords, I could now keep away volume 4 and go to the authorities. Jurisdiction, my lords, at any rate in our jurisdiction, is not conferred by the parties. The parties cannot go to a court and give it a jurisdiction which the court does not have. However much the parties said that we are giving you this jurisdiction, is in law, the court has no such power. The court cannot assume jurisdiction because the parties are anxious to get on with the case. I request, my lords, to turn to authority number 13, Samuel Kamau Macharia. This will be at page 119. List of authorities, authority number 13, page 119. And the principle of law, my lords, is it will be found at page 137, page 137, the last sentence. Of course, jurisdiction flows from either the Constitution or legislation or both. Thus, a court of law, and then over it, can only exercise jurisdiction as conferred by the Constitution or other written law. It cannot allocate to itself jurisdiction exceeding that which is conferred upon it by law. We agree with counsel for the first and second in a submission that the issue as to whether the court of law has jurisdiction to entertain a matter before it is not one of mere procedural technicality. It goes to the very heart of the matter. For without jurisdiction, the court cannot entertain any proceedings. And then the judges quoted many other cases. But may I say this, my lords, it's old hat now in our law, it's an old hat, it's trite law, that a court cannot take a matter, deal with it, when it is quite obvious, plainly obvious, that the court has no jurisdiction. The case before you is even compounded by yet another vice. The fact that from August 2011, by an act of Parliament, conciliation was taken away from judges of this country and given to another set of persons. I move to authority number 14 on the list of authorities, still on this theme. This starts at page 140, and the principle of law would be at page 146. Page 146, another Court of Appeal decision on this point. I request, my lords, if you could please turn to page 146, letter G, G for geography. The sentence at letter G, only one sentence. The proceedings were a nullity as the court acted without jurisdiction. And on this theme, my lord, so that I go on as I close on this theme, the attack, the complaint is twofold. Twofold in the sense that the judge, on one hand, considers he has been given jurisdiction by the parties, a jurisdiction which he does not have. But the first leg of the complaint is that the parties didn't give him that power. In other words, there was no consent. And the second limb of the complaint is the judge took conciliation proceedings, which in law he is not entitled to undertake. So on those two complaints, my lord,